Good afternoon. My name is Matt Robbie, and on behalf of Christian Brothers Services, I would like to welcome you to our Spring 2019 webinar series. Over the next several webinars, our topics will explore contract analysis, cybersecurity, Medicare, plan giving, and many other topics. For a full listing of all of our webinars and their dates, please visit cbservices.org/webinars.php. Today's webinar, the sixth in our series, is entitled Sexual Harassment and Abusive Conduct in the Workplace. Before we get started, I would like to cover a few housekeeping items. Please note that audio will stream through your computer, so please make sure that your speaker volume is up and at an audible level and your flash player is enabled. A copy of today's presentation can be found by clicking on the light green icon with a piece of paper on it at the bottom of the screen. You'll then be able to download the presentation. We will be using a lecture format for today's webinar with a few interactive questions. Our presenters will answer your questions at the end of the presentation. However, at any time during the webinar, you can type your question into the question box, which can be found at the left side of the presentation window on your screen. If your question box is not already opened, you can open it by clicking on the purple Q&A icon at the bottom of the page. Just type the question box and hit submit. At the end of the presentation, please take a moment to let us know what you thought about today's webinar and our speakers. On the right-hand side of your screen is a brief 5-question survey. By completing the survey, you are not only providing us and the presenters with valuable feedback on today's webinar and topic, but you will also be given the opportunity to enter a drawing for a $100 gift card at the end of the webinar series. Now, before we get started, let us remember that we are in the holy presence of God. Creator God, through your world and the people that surround us, we pray that we may grow more aware this day of your life-giving presence. Open our minds and hearts to apply the knowledge from today's webinar for the good of all. We ask these things in Jesus' name. Amen. Thank you. Let me introduce today's presenters. Andy Copon. Mr. Copon is the founding partner of Copon Erdo LLC. His practice focuses on handling of complex civil litigation matters, including catastrophic injury and wrongful death cases. He has tried high-profile cases and has argued in federal and state appellate courts and the Illinois Supreme Court. Mr. Copon's trial practice is in a variety of areas and includes production liability, professional malpractice, employment law, and insurance coverage cases. He currently serves as National Counsel for the Religious Risk Pooling Trust that covers educational institutions, nursing homes, and missions of religious institutes. Mr. Copon has the privilege of serving as the current president of the International Association for Defense Counsel. Mr. Copon is a charter member of the Leading Lawyers Network Advisory Board, whose members are selected based upon their reputation and professional ethics. He has been named to an Illinois Super Lawyer for 2018 and in multiple prior years. He is a former member of the Board of Trustees of Loyola Academy located in Wilmette, Illinois. Mr. Copon is a 2018 honoree of the De La Salle Institute Founders Award. Also presenting today, Colette Copon. She is an associate at Copon Erdo LLC. Ms. Copon focuses her practices in complex civil litigation matters including commercial disputes, employment law, professional malpractice, insurance coverage, product liability cases. Ms. Copon also has substantial experience conducting internal investigations and counseling clients in connection with investigations and regulatory actions by the U.S. Securities and Exchange Commission. Previously, Ms. Copon has served as a judicial law clerk for the Honorable Virginia M. Kendall in the U.S. District Court of Northern District of Illinois. While in law school, Ms. Copon was the president of the Moot Court Honor Society and received CALI awards for earning the highest grades in her trial advocacy, evidence, pretrial litigation, and federal court classes. Please welcome Mr. Andy Copon and Ms. Colette Copon.
Well, thank you, Matt, Kevin, Jeff. It's our pleasure to be with you this afternoon. Good afternoon, and thank you for joining us today as we discuss the important topics of eliminating harassment, specifically sexual harassment and bullying in the workplace. As Matt noted, we've had the privilege of representing the Christian Brothers Risk Pooling Trust members for over 30 years now. I've probably worked with some of you who are in the audience, and I know, and Colette knows, that you're all out there doing great work and working for great organizations. So thank you for your service to others. I'd like to introduce Colette. Colette's my partner. She's in charge of our employment law team. She made partner effective January 1st, so that's a little typo that she was giving me a hard time about. but we are pleased to be with you this afternoon. Before we talk about today's program, I'd like to tell you about our Employment Law Manual. The Employment Law Manual started in 1997, and we update it every year. And right now it's hot off the presses. So if you'd like to receive a copy of the Employment Law Manual, please contact our legal assistant, Susie Rios. Susie can be reached at that email address that's on your screen there. And just to tell you a little bit about the Employment Law Manual, first you can receive it in an electronic PDF format, or we can send you a hard copy if you prefer to access the hard copy. But it runs approximately 200 pages, and every year we revisit it to make sure that the case law that we're citing to you and the principles that we're discussing are still current and relevant. And then we're updating that because the employment law area is an area that is constantly changing. The federal docket, about 20% of their cases are made up of employment-type cases. And we'd like to make sure that we're keeping the Employment Law Manual up to where it needs to be. The first 2/3 of the manual discuss substantive laws pertaining to the employer. So discusses Title VII, which we will talk about in great detail today. It talks about sexual harassment, it talks about the Age and Discrimination in Employment Act, the Americans with Disabilities Act, FMLA, and another 8 or 9 statutes that regulate an employer's conduct in the workplace. And then what we do is we take that case law and for the remaining 1/3 of the manual, reduce that to what we call employment considerations, the nuts and bolts for the employer. What does this law mean? When I go about making job postings, what should I be considered about? What type of words should I use? What type of words should I avoid when posting for a job in our organization? What type of things should you know about when you're conducting pre-employment screenings, conducting criminal background checks? What's the best way to go about hiring? What type of interviews, when you're conducting an interview, what type of language should you use? How can you get the information that you need from a candidate without violating the Americans with Disabilities Act? Those are all the types of things that we discuss in the last 1/3 of this book. We also have a section on employee handbooks. So if you're contemplating drafting an employee handbook or you're revisiting your employee handbook to make sure that it meets the current standards, our manual would be a good resource for you. And it's free of charge. So feel free to contact Susie Rios, and we would be happy to send you a copy of it. Because our goal is to keep you out of our workplace, which is the courtroom. As much as we enjoy being there, I've never had a client tell me that they like being there with me. So we hope that with our 2-hour presentation today in the area of sexual harassment, that we help you avoid litigation, and that most importantly, we help you to continue to work and strive to build a culture and an environment that is one born of respect, that the employees understand that, and that message comes from the top. So let's get started then. I'll talk about today's agenda and how we're going to handle the topics that we will address with you. Is I will talk to you for the next 55 minutes or so, and I'm going to be talking on the topic of sexual harassment and what that means under Title VII. We'll talk about the history of sexual harassment law and what the current practices are in the area of preventing sexual harassment and moving your workplace forward with the best policies and best practices. Then I'm going to turn it over to Colette, and Colette's going to see if you were paying attention to my presentation because she's going to conduct a quiz that you can all participate in. And then after conducting the quiz, and the quiz is not, I was being facetious, of course, to see if you were paying attention, but the purpose of the quiz, it's also part of the training. It's to help you to organize your thoughts in this area of preventing sexual harassment and satisfying the affirmative duty of preventing harassment in the workplace. And then after the quiz, Colette's going to talk about state law considerations, looking at the major jurisdictions throughout the country, and then talk to you about her insight on the best way to go about conducting workplace investigations with a focus on conducting sexual harassment investigations. And then she will also talk about abusive conduct and bullying in the workplace and how to go about eliminating that. So why don't we begin then, and I'll talk to you about the EEOC, which is where this starts. Because the EEOC starts out like the rest of the federal government, and they run on a fiscal year. And their fiscal year ended on October 31st, 2018. And based on the data that the EEOC is posting on its website, and I always recommend this website, the EEOC.gov, because the website is full of data, and what the data shows is that the EEOC, one of its main initiatives is to eradicate sexual harassment in the workplace. Their figures are posted for 2018, and they go back more than a decade. So you can see, comparatively speaking, what type of charges they received throughout the year, what types of charges are trending upwards, and which ones are trending down. And what we know from the EEOC data, that they have put forth a significant effort to address what it has described as a pervasive problem in the workplace of sexual harassment. The acting chair of the EEOC, Victoria Lipnick, recently reiterated that combating all forms of workplace harassment, whether based on sex, race, color, disability, age, national origin, or religion, remains a top priority of the EEOC. So although we will be using the term sexual harassment throughout this talk, you should also be thinking in terms of harassment in general. That if somebody is being harassed for any reason, particularly if they are a member of a protected class, and that's the basis of the harassment, it needs to be stopped before it starts. And part of this is when you talk to the people who study this area, the psychologists who work in this area, and look at the current media attention, the heightened demand of the hashtag #MeToo movement, it makes it clear that the workplace harassment is not only unlawful, it's simply unacceptable. And the EEOC is working to eradicate it. The American Psychology Association, which is the major association for psychologists throughout the country, recently issued a white paper. And that white paper is entitled, "What It Really Takes to Stop Sexual Harassment." And the paper starts out by stating that according to psychologists who study workplace harassment or provide consultation to companies on how to prevent it, sexual harassment is a pervasive problem with a devastating toll on employee well-being and performance. A psychologist who specializes in this area notes in the article that organizations still have a knee-jerk reaction to sexual harassment complaints. They tend to close ranks, admit nothing, and blame the victim, making it difficult for the Human Rights Department to do their job. So this is something that the EEOC is addressing. This is something that the healthcare professionals who work in this area are sounding the alarm about. This white paper goes on to advocate that companies need to adopt a comprehensive approach to combat sexual harassment in the workplace. It cannot just be a one-time training program, because attitudes have to be changed to encourage people to come forward. It requires a culture change. So the topic that we're talking about, and Christian Brothers provides this service to its members at least once a year, and sometimes twice a year. We gave this talk back in November, and we try to keep it fresh. So there's cases coming out all the time in this area, and the EEOC is also very active in this area. And just since the last time we spoke on this topic in November, there's been quite a bit that's been happening. Because when you're going against a culture that's been entrenched for a long time to eradicate something that is unhealthy and damages not only the individual that's being harassed, but it just deteriorates the entire workplace culture, that all resources need to be brought to bear. I like numbers myself, so for those of you who out there share that interest, I have some numbers for you. This past year, when you look at the EEOC data on their website, the EEOC filed 66 harassment lawsuits. Out of those 66 harassment lawsuits that they chose to litigate, 41 included allegations of sexual harassment. That's almost 2/3 of the lawsuits filed by the EEOC were sexual harassment type lawsuits when you look at the spectrum of harassment lawsuits. In addition, they filed charges alleging sexual harassment that increased by close to 14% from the year before. And when the EEOC actually sues in the name of the aggrieved employee, they recover money. And in the past year, they recovered $70 million for victims of sexual harassment through litigation and administrative enforcement. That's up $22.5 million from the prior year. So the numbers show the EEOC's commitment in this area of enforcement. The EEOC receives approximately 85,000 complaints of discrimination every year. Sometimes it goes up, sometimes it will trend a little bit lower, but on average they receive 85,000 total complaints of discrimination. About 1/3 of those charges involve allegations of harassment. And of those harassment allegations, almost 50% involve allegations of retaliation, which is something we will talk about a little bit later today. So I'd like to note at this time what's interesting, that even though we see these numbers trending about sexual harassment complaints being filed with the EEOC, and we see an increased enforcement by the EEOC, the social scientists who study this area of harassment have found that 80% of employees who experience harassment never file a complaint of harassment. And that demonstrates the seriousness of this issue when it goes unreported for reasons that we'll talk about later, and that becomes the silent cancer killer to the workplace culture. And that's why what we're going to be talking about is how to change that mindset, how to change that culture. The EEOC, a little bit over 2 years, I guess it was more like 3.5 years ago, they appointed a 2-year task force that studied harassment in the workplace. And the task force was composed not only of lawyers for victims and employers, advocates, but also of social science practitioners and industrial organizational psychologists, people who commit their life to studying workplace harassment. And what this task force found was that what the white paper also said, that harassment remains a persistent problem. It too often goes unreported, and it is an area that needs training and accountability. The same findings that were addressed in the APA's white paper that I just discussed. The task force came out with 5 core principles about a year ago. The 5 core principles, which they believe will prove effective in preventing and addressing harassment, are principles that will work through today's presentation. And then the first core principle starts with leadership. The leadership must be committed and engaged. That the message has to come from the top down when it comes to not tolerating harassment in the workplace. And the second core principle is that the leadership and the commitment must be consistent and demonstrated accountability. It cannot be that we're going to have one training session and that's it, or we're going to have one policy and that's it. It has to be consistent. There has to be a demonstration by the people at the top that sexual harassment will not be tolerated, that it must be frequently stated, and the policies need to be revisited on a constant basis. The third core principle is that the employer must have strong and comprehensive harassment policies. Harassment policies are different than employee handbooks. Whether you have an employee handbook or not is a separate discussion, but you must have a harassment policy. you must certainly have a sexual harassment policy. And the fourth core principle articulated by the task force is that you must have a trusted and accessible complaint procedure for sexual harassment. And your trusted and accessible complaint procedure must be regularly communicated to your employees. And the last core principle is that you have to have regular interactive training that's tailored to the audience and the organization. Because the purpose of the training, and what we hope to accomplish today, is you take steps to prevent sexual harassment before it occurs, that if it does occur, your people are educated and they can recognize it. And then when they recognize it, they report it, and then the employer has a mechanism in place to respond to it. These five core principles were taken by the EEOC, and they rolled it out into training modules about a year and a half ago. And those training modules are designed to assist employers in preventing workplace harassment. The EEOC rolled out 2 training modules that are interactive. You can find this information on their website. They can lead you to the resource for this. And that is a training module captioned Leading for Respect that is designed for supervisors and managers. And the other training module is Respect in the Workplace, which is designed for all employees. So what I'd like to do now is also make mention, when I said there's been a lot happening just in the past 4 months since we last talked on this topic. It involves a roundtable that was held by the EEOC just this week. On Wednesday, March 20th, the EEOC held a high-level roundtable discussion of harassment prevention in the workplace. The roundtable included leaders from various types of industries, including education, colleges, universities, healthcare, the president of the American Bar Association, and various association leaders, including the Human Resources Association leaders. And during that roundtable, the EEOC's acting chair, who I mentioned, Victoria Lipnick, was quoted as saying that the EEOC stands ready to help in the effort to change workplace cultures to be more respectful and inclusive. So we see the EEOC is acknowledging that it's committed to expanding into the area of critical analysis, education, training, and not just enforcement to make a dramatic change in eradicating the problem of harassment in the workplace. So let's talk about where this all starts from. This all starts with Title VII. And Title VII has been on the books since 1964. And that's the federal law that sexual harassment law derives from. It's simply stated it prohibits discrimination against any person based on their status of being a member of a protected class. So as simple as that is, since 1964, we're about almost 55 years now, we've got a well-developed body of case law interpreting Title VII. Whenever there's new legislation regarding discrimination, whether it's at the federal level or the state level or the municipal level, these governmental bodies will always look to Title VII when they're developing their statutes or regulatory schemes because of the time that the courts have had to develop case law to give employers insight on how to avoid being sued and eradicating, for our purposes today, sexual harassment in the workplace. I would just point out that although Title VII applies to employers with 15 or more employees, most states, including Illinois, have their own regulatory scheme, statutory scheme regarding harassment, and they have a lower threshold than 15. So if you have 10 or 12 employees, you necessarily can't take comfort in the fact that you may not be governed by Title VII because your state statute might govern you. In Illinois, if you have more than one employee, you are governed by sexual harassment discrimination state law, which again is very similar to Title VII. And when we talk about protected classes, these are the protected classes that we're talking about. The Title VII states that it's unlawful to discriminate against anybody because of their race, color, sex, national origin, and religion. Now, religion becomes a little bit of a more delicate topic when we're talking with religious organizations, and our employment law manual devotes chapters to this issue of what exemptions do apply when it comes to discrimination on the basis of religion. But I think everybody knows that when we're talking about sexual harassment, it doesn't matter what religion you are. Sexual harassment is prohibited in the workplace, and that applies to any organization that has more than 15 employees under Title VII. For purposes of gender discrimination or sex discrimination, that also includes, according to the EEOC, sexual orientation. That sexual orientation is a protected class based on the EEOC's interpretation of Title VII. The federal courts, right now, there's 2 federal appellate circuits that agree with the EEOC's position regarding sexual orientation as a protected class. The Supreme Court has not directly addressed the issue yet. Many states have. There are 20 states that have addressed sexual orientation as a protected class, and I think most major urban cities have as well. These protected classes that are on the top of this line, race, color, sex, national origin, or religion, are provided for in Title VII. The ones below the line come about from subsequent statutory legislation passed by Congress. So for our purposes and as an employer, just think of age. Although age is a protected class that comes out of the ADEA, the Age Discrimination and Employment Act statute, just think of it as a protected class. It will make your life and your analysis easier as you go forward when you're making your employment decisions. Disabilities under the ADA is essentially a protected class that has a little bit of a different analysis when it comes to discrimination, because it gets into a discussion of providing a reasonable accommodation for somebody who's a qualified individual who suffers from a substantially life-limiting disability. Pregnancy is a protected class under the Pregnancy Discrimination Act that was passed shortly after Title VII was passed. And when we were talking about sexual harassment discrimination, we're talking in essence about discrimination against a person because of their status as a member in the protected class based on sex or gender. And every aspect of the employment relationship is governed by Title VII. That means it's unlawful to discriminate against any employee in any of these areas of hiring, discipline, transfer, even post-job references. Even though the employment term has ended, if, let's say, the employee quit and a prospective employer is coming back for a job reference and a negative job reference is given, if that person was a member of a protected class and they believe that the motivating factor in that bad reference was because of their status as a member of a protected class, they have a right of action under Title VII. So just because the employment term has stopped doesn't mean that Title VII isn't far-reaching. So the courts operated under Title VII for a few decades, and when people stopped to look at whether or not the results were being achieved that Title VII sought to achieve, the conclusion was it needed more teeth, that more needed to be done to protect people who were members of a protected class who were still being discriminated against in the workplace. And as a result of that, Congress passed the Civil Rights Act of 1991. So in 1991, Congress stepped it up. And the way they stepped it up to provide teeth to Title VII was to say, we're going to do 3 things. We're going to give the person making these allegations of discrimination the right to a jury trial. Because before that, the judge would decide the case. The judge was the decider of fact. And what the studies were finding is that when judges decide cases, the awards tend to be lower. I mean, that's the bottom line. When the jury decides cases, the verdicts tend to be higher. when a judge decides a case, verdicts tend to be lower. It's a generalization, but it was one of the articulated reasons for giving the right to a jury trial. And the other thing that you should be considerate about is that juries primarily are made up of employees and not sole proprietors. That's not a hard and fast rule, but I mean, it just makes sense. If you get 12 people in the jury box, or a federal court, if you have 6 people in the jury box, they will mostly be employees who are going to start off relating to the plaintiff in the case. Now, the second weapon that Congress gave in the Civil Rights Act of 1991 was to increase the nature of damages that could be claimed by the plaintiff. And those damages went from a strictly financial analysis of how much pay did you lose when you were sent home for 2 weeks without pay, or how much money did you lose when you were fired but got another job in a month. Instead, Congress said, we need to incentivize the plaintiff's bar to take these cases because we want to eradicate discrimination in the workplace. And sometimes discrimination may not have a significant financial toll to it, although the human loss is great. That doesn't necessarily equate to the financial loss. So by now saying that the aggrieved employee can obtain compensatory damages, which would be for the intangibles, the emotional pain and suffering, the things that you can't necessarily predict what a jury will do with. So if somebody was off work for 2 months, we can calculate that and say the downside to this case is going to be 2 months' salary and attorney's fees to the other side if they prevail. But now, if they can recover from mental pain and suffering and describe what they went through for those 2 months when they were looking for another job and trying to take care of their family with maybe a newborn baby, something like that, that's going to increase the stakes for what can be recovered at the time of trial. And the third weapon in the arsenal in the Civil Rights Act of 1991 is punitive damages. And punitive damages is another one of those intangibles. So you can see that what the message that Congress sent in 1991 was that we're serious about eradicating discrimination in the workplace. The EEOC can do so much, but we want to incentivize plaintiffs' attorneys to take these cases. We want people to come forward and see this to the end, and we want to make sure that we're doing everything we can to stop discrimination in the workplace. So I guess the bottom line is the stakes are high, and that takes us to the issue of damages. What I just talked about were the additional damages recoverable under Title VII, and now this gives you an idea of the other elements of damage that show the seriousness of what we're talking about. And the first one is injunctive relief. And when we're talking about injunctive relief, that means that the court and the EEOC have the power to make the employer do something or refrain from doing something, and it's not necessarily financial in nature. So this gives the courts the power to tell an employer to have training in the workplace, to post violations in the workplace, and they have the ultimate power of taking, if it's an aggrieved employee who was fired, to put that person back into the workplace. So the remedies that are available to the EEOC to combat discrimination in the workplace and the power that the courts have is injunctive relief, reinstatement, the financials, the back pay, the front pay, attorney's fees. So it's an attorney fee shifting statute, so that if the other side prevails, they recover their attorney's fees at the end of the case. And then there's also compensatory damages, which have a cap associated with them, which I'll show you that slide in a second, and punitive damages, which also have a slide associated with it. These caps are on the non-economic damages, and that depends on the number of employees that you have in your workplace. But again, I would not take too much comfort in that because, like I have said earlier, states have their own parallel statutory schemes, and many state statutes do not have caps. So we see sometimes where we're defending not only lawsuits brought in federal court, but there may be counts that are also predicated upon state law statutes for this reason, that there are no caps in what can be recovered in the non-economic section of the damages. So you can see that these cases are expensive, and it results in damages that are high. So what we're talking about today is to avoid this, to avoid the big dollars that are equated with finding yourself involved in a discrimination case with particular focus on the sexual harassment side of things. So what happens in this case, by their very nature, is they become fact-intensive at the beginning of the claim coming in. So when the case comes in and we get a call that you've received a notice of charge of discrimination, and we come out to your location, and what will happen is that we're going to be asking for a lot of records, and we're going to be asking to interview a lot of your employees. So it's going to be disruptive to your workplace. And this all has to take place quickly because the EEOC and most state regulatory agencies have pretty quick turnaround times for us to have to draft a position statement and to draft a response to the charge of discrimination. And it's not like an automobile accident case where we can just file a document denying allegations and then build the case as time goes on. This requires us to come out immediately, throw resources at it right away, and to find out what our closing argument is going to be in essence, so that we know when we make that position statement, we know what we need to know. And that results in a lot of front-end costs, and that makes it expensive for risk pooling trust and others on the defense side. And then if the case is lost, then you also have to pay the damages for the other side. And then you also have to pay all these other damages that we talked about with respect to economic damages and non-economic damages and potentially punitive damages, which generally speaking are not covered by any insurance. So let's talk a little bit then about how you stay out of litigation. And I think probably the best way to start, and this is just more of an overview of discrimination law in general, but it also applies to sexual harassment law as well. And that is proving a Title VII claim. How do you go about doing that? And since the courts have had years to do this, back in 1973, the United States Supreme Court issued a landmark decision, McDonnell Douglas versus Green, and they put forward a burden-shifting analysis, which ties into this disparate treatment focus of proving a Title VII claim. Direct evidence is, I'm not going to talk about direct evidence a lot here, because direct evidence, the way you prove a Title VII case on the direct evidence is the Perry Mason way. That's where the witness takes the stand and breaks down crying and says, you know, I fired her because I think a woman's place is at home and isn't in the workplace. That's direct evidence. We go from that type of statement on the stand back to the damages slide. That rarely happens, if ever. The disparate impact claim in a discrimination setting means that it goes to policies. It tends to be a gender type claim where an employer has put in what appears to be on its face a neutral policy, but its impact falls adversely on a protected class member. It tends to be gender-based. So, for example, if there's a lifting requirement in a nursing home, that a CNA has to be able to lift 200 pounds. Now, what the studies find is that that will disparately impact women versus men, and that type of policy will be stricken. So our focus today is going to be disparate treatment then. And when we talk about disparate treatment, we get into this burden shifting analysis of McDonnell Douglas versus Green. And what happens with the burden shifting method is that the plaintiff comes forward. The person making the allegations needs to state a prima facie case. And what the court has said is that the prima facie case essentially, you have to show that you're a member of a protected class. That's obvious. 2, that you were meeting legitimate expectations. You were qualified for the position. And that 3, you were adversely impacted by an employment decision. Once the plaintiff shows those 3 elements, a prima facie case has been established. And when the prima facie case has been established, then something unique happens in the law. And what happens in the law is that the burden of persuasion shifts to the employer. And the employer now has an obligation to come forward. And the employer has to articulate legitimate, non-discriminatory reasons for the adverse employment decision. I say that's unique in the law because, take any other field, again, just taking a simple car accident case, the plaintiff has the burden of coming in and saying, I was in a car accident. They have to prove it was the other person's fault. They have to prove they were damaged. And the person driving the other car doesn't have to say anything. Nothing at all. No burden of proof. They can just say, they didn't prove their case, and they can win. But in this context, in trying to determine whether or not somebody's making an adverse employment decision based on discriminatory reasons, as I just explained, direct evidence is rarely present. The discriminator is stupid enough to discriminate, but is smart enough to mask the reason for making the adverse employment decision. So the courts say, and again, this goes back to everything being fact-intensive. This is the reason we come out to your place right away, because we need to get all the facts. Because when the case is ultimately decided, the trier of fact, which most likely now is the jury, is going to consider all these facts to decide whether or not the person was substantially motivated by a discriminatory reason in making that employment decision. And as a result of that, at the early stages of the litigation, the employer has to articulate legitimate, non-discriminatory reasons for the adverse employment action. If they just sit back, what I get sometimes from people in management, they'll say, well, we're an at-will state. And because we're an at-will state, nobody has a right to a job, and I could fire them for no reason at all. And my response to that is, typically that might be true, but if you're dealing with somebody and you've made an adverse employment decision, and this decision was against somebody who's a member of a protected class, you can't fire them for no reason at all. You have to be able to articulate legitimate, non-discriminatory reasons for the adverse employment action. And those are reasons that you have to be able to point to. And then what happens is once the employer articulates legitimate, non-discriminatory reasons for the adverse employment action, then the burden of proof goes back to the employee or the plaintiff. And the plaintiff then has the burden. The burden of proof always stays with the plaintiff. This is a little bit of a legalese here. But the plaintiff then has to establish that the reason that was articulated by the employer was pretextual, which means it was a lie. That reason was a lie to cover up the discriminatory motive that was behind the adverse employment decision. So I like to, I give a couple of simple examples to demonstrate this point. And one example I like to give is where a company had a policy that they had all the ducks lined up in a row. They had an attendance policy that if you're, you get a 1 hour lunch period. If you take longer, you can be subject to discipline up to and including termination. And a woman went home for lunch one day. She came back 20 minutes late, and the employer fired her. So the employee filed a lawsuit and said, you discriminated against me because of my status as a member of a protected class of sex. And the employer then said, but I have a written policy, so I have legitimate reasons. My policy says you only get an hour, and you took an extra 20 minutes. And it also said you might be fired. So these are all legitimate reasons that I'm articulating. The burden with the plaintiff then was to show that that was really pretext. Those were just excuses, that it was a lie. And what the plaintiff showed in this case, and it's a real case, she was able to show that 4 men in the past 6 months had come back late from lunch. And they were disciplined, but not terminated and not fired. And she had otherwise been doing the job properly. So in that context, the court said, there's enough evidence there that I'm not going to grant summary judgment. I'm not going to throw it out of court. Therefore, this case goes forward. So if she had not been able to, if the employer had been administering its policies uniformly, and this is where employers get in trouble sometimes. They'll play favorites, and playing favorites will get you in trouble. So that's why when you have policies that are good policies, when it comes to enforcing those policies, if you're enforcing those policies and you're not doing it uniformly, you're going to be subject to an argument that you're acting pretextually. And that's why you always need to do the hard thing sometimes. It might be a friend of yours that you're supervising that you need to take action against. And that person needs to be treated the same way every other employee in your workplace should be treated. It's a basic sense of fairness. You know, some of this stuff seems like it's common sense. When you're dealing with human relationships, sometimes what seems to be obvious is not so obvious. So that's why when we talk about culture, sending the message from the top, that the employees that work with you trust you, understand that they're working in a place where they're going to be treated fairly. Because a lot of this comes down to what the perception is in the workplace of the decision maker. Another case, and this is a brand new case that I'm working in for the first time. This involves a case, and this goes to the legitimacy of the reasons that are articulated by the employer. This was a case that the EEOC filed on behalf of a plaintiff against Target Corporation. And in that case, the court held that the employer did not meet its burden of persuasion, where its entire explanation was based solely on the fact that it did not hire a candidate for a job based on the interview. So the person applied for a job. They did not get the job. They were a member of a protected class. So they came into the courthouse and said, you know, I didn't get the job, but I think I was discriminated against because I'm a member of a protected class, and I was otherwise qualified for the job. When the burden went to Target to articulate the reasons, their legitimate reason that they gave was that he did not meet the qualifications for the job, and therefore we elected not to hire him. And what the court said was, you know, that's not enough. Just saying that he didn't meet the qualifications of the job without more detail, this explanation does not frame the dispute that the plaintiff can respond to Target's asserted reason with respect to specific evidence that this reason was a pretext for discriminatory motive. So you have to be very thoughtful in this area when you're making adverse employment decisions, whether it's your reasons for not hiring somebody, your reasons for disciplining somebody, or your reasons for discharging somebody. They're going to have to be reasons that are legitimate, well thought out, that when you put them forward, they're not going to be subject to challenge. Because again, this is a very fact-intensive inquiry that the trier of fact will ultimately make. So those are the examples that I have right now. Let's talk about sexual harassment. There are essentially two types of sexual harassment type cases that we see that the law recognizes. The first type is a quid pro quo, which means, you know, something for something. It's essentially where someone's job is impacted negatively or positively due to a quid pro quo. And that doesn't necessarily mean that it's only the person who's being victimized by the harassment. It could be somebody else. It could be a colleague that because of this quid pro quo relationship is being negatively affected by that type of a harassment. So the quid pro quo harassment is a cause of action recognized by the courts. And the second one, which is the one that we tend to deal with more frequently, and that's the hostile work environment. And the hostile work environment, I would start up by noting the law requires that you prevent the hostile work environment from ever occurring, but it's a situation that can be created not only by coworkers, but by non-employees as well. So, for example, if a client is sexually harassing an employee, that conduct can make the employer potentially liable for sexual harassment based on a hostile work environment. So when employers receive complaints of sexual harassment, if it's from a vendor coming onto the premises, if it's with a client that an employee is interacting with, or whether it's another co-employee, the reaction by the employer needs to be the same when it starts to conduct its investigation, which Colette will talk about shortly. But the hostile work environment is another area where we have a well-defined body of law under Title VII. And the hostile work environment is one where the workplace is so permeated with harassment on the basis of sex that the conditions of employment are altered and a hostile or abusive work environment has been created. In other words, an employee should be able to come to work and do his or her job without being sexually harassed, period. The employee is not expected to have to come to work and tolerate a hostile or abusive harassment environment. And this is an area that we do have a lot of cases because I would say typically it's not a stray remark will not give rise to a hostile work environment. One incident alone, generally speaking, does not give rise to a hostile work environment. But it depends on the circumstances, and the court acknowledges that. The court says this, again, is very fact-intensive, and it could be based on one act, if it's by a supervisor or a manager, and it involves an offensive sexual touching, that could constitute a hostile work environment. So I would say, for context, and generally speaking, it's more than just one act, or more than just one straight comment. It has to be a work environment that is deemed to be hostile or abusive by a reasonable person who would find it offensive, and that the employee actually perceived it as offensive. So it's really a two-pronged analysis when a court is trying to determine whether or not a hostile work environment exists within a work environment. It has to be judged by an objective standard of reasonableness, and there's also a subjective standard that comes in with respect to the person who was the object or subject of those acts or comments perceived it as being hostile. So with that being said, what I'd like to do now is talk in general about what an employer's duty is, because we know that we have quid pro quo and we know we have a hostile work environment. Now, what does that mean to the employer? And what the courts have said, and the way we started out this talk, is what the EEOC has said as well, is that the employer has an affirmative duty. And because the employer has an affirmative duty, that means the employer has to take measures beforehand to try and keep sexual harassment out of the workplace. The employer cannot just sit back and do nothing beforehand and hope to win the case by merely stating that I conducted a good investigation and I terminate the person. Those may have been the right steps to take, but if the employer did not engage in affirmatively take steps to prevent that from happening in the first instance, the employer can still be found liable for that sexual harassment that occurred. And this is why the EEOC is spending its resources of time and money on task forces, initiatives, roundtables, to educate employers and employees in this area of how to go about preventing harassment in the workplace and how to create a culture of respect for your employees. You have to have affirmative duty, you must be proactive, and one of the most important ways that you go about doing that is not only through training, like attending this webinar today, which helps to educate the workforce on identifying harassment, but also how to respond appropriately and how to have your policies in place so that you wind up with a good culture and you achieve respect in the workplace. So let's talk about sexual harassment policies. Let's get down a little bit more into the nuts and bolts here. And unlike employee handbooks, the employee handbooks, you may have one, you may not have one. There's no requirement that you have an employee handbook, and you'll, in deciding whether or not to have one, you take into consideration the size of your workforce, the complexity of your operations, and whether or not you need an employee handbook. But regardless of your size, regardless of the complexity of your operations, you must have a written sexual harassment policy. There's no ifs, ands, or buts about it. And if you're in management, you're responsible for this sexual harassment policy, you should revisit it annually. Because as I said earlier, we have psychologists studying sexual harassment policies, and there's changes and there's tweaks that are made to try to have best practices in place with respect to the sexual harassment policy. So the first point is it has to be in writing, and it should be given to all of your employees. It should start with the onboarding process. It should be given to all new employees. After they've read the policy, when they start on the first day of employment, they should understand it, they should sign it, and then the employer should keep a copy of that signed sexual harassment policy in the employee's personnel file. And I also recommend that you give a copy of it to the employee. That helps to not only be engaged in best practices, but I think that sends the message on the first day. That helps to set the tone about the culture and about the leadership in your organization at the outset of the employment relationship. And you should also revisit the harassment policy throughout the employment term. You've taken a lot of time and effort to devise a good sexual harassment policy. You've taken time to explain it to the employee when they start it. I counsel that you should revisit it once a year during the employee's annual review when you're seeing how things are going. Remind them of the sexual harassment policy. Ask them if there's any problems, or if they have any questions about anything. Because again, that helps you to exercise your affirmative duty of keeping harassment out of the workplace. The policy should also define sexual harassment, and it needs to state the consequences, including termination if someone engages in harassing behavior. And probably, I would say, most importantly, the policy has to encourage people to report. And this policy has changed over time. When I talk about those changes that occur in sexual harassment policies, this is one of the big areas, and that's to encourage reporting. It wasn't that long ago where somebody would make a complaint of sexual harassment, and the employer, going back to that knee-jerk reaction comment and how people close ranks, the employer would be given to say that, look, these are very serious allegations. You can ruin a person's, likely a man's, career. I want you to put this in writing and sign it. Well, what that does is that does not encourage somebody to come forward to make the complaint of sexual harassment to a manager or supervisor. That sends just the opposite message. That sends the message of, we don't want to hear about it. We don't want to know about it. You're a troublemaker. And these are the types of reasons people do not come forward. I quoted the statistic that even though the numbers are larger and larger with people reporting it, 80% of people do not report sexual harassment, which undermines the culture in the workplace. When you read literature in this area, what motivates sexual harassers? They say it's not sex, it's power. All this is about power. So when you're dealing with somebody who's abusing power in the workplace, you want to get to the root cause of it. You want to encourage people to come forward. You do not require that it has to be in writing. You do not require that the complaint has to be signed. And in fact, if you want to encourage people that if they see sexual harassment, that they report it, even if it didn't occur to them. If they overheard something that was in violation of the policies, that they report it, that they feel empowered to come forward, so that you can then trigger your investigation mechanisms to see what's going on in the workplace. And this is the best way to guarantee it, is to encourage the people to come forward so that they're not afraid of losing their job, that they won't be viewed as a troublemaker, that they won't prejudice their chances for advancement in the workplace. That's why you want to make sure you have a nurturing reporting requirement. What happens sometimes in this area is that the person making the complaint or reporting the allegations of sexual harassment, they felt strong enough to come forward, but by the same token, they want to govern the outcome of it. So they'll say something, Mr. X was harassing me, but I know he's married, I know he's got children, I don't want him to lose his job. I just want to let you know, but I don't want you to do anything. That happens sometimes. But when that happens, you know what you have to do as the employer. You have to do the right thing. You have to exercise your affirmative duty. And you've got competing interests going on here. You want to encourage the person to come forward. You want to encourage them in participating in the investigation process. And you also need to take steps in investigating the charge. So in responding to that type of employee who's making these allegations, it may not be something that happened to them. It may be something that they were told this by another employee. So they don't want to be perceived as being a gossiper. I think you have to give them assurances that you will hold this in confidence as much as you practically can hold it in confidence, but that as an employer, with the culture that you have and the respect that everybody needs to have within the workplace, that you are duty-bound to investigate it, and that you will investigate it, and that you will hold them in confidence to the extent possible. And then proceed, and Claire will talk about how you go about doing this, but you go in and proceed and you try to protect that confidence where you can. But you need to be supportive, but at the same time, when you're being supportive and protective of the person making these allegations, you also need to go forward and conduct a thorough and responsible investigation with respect to these types of allegations. The reporting process, and this I guess is part of encouraging people to come forward, is you want to include a variety of people who they can make their reports to. One safety check is you don't want to make it one person. Even if you're a small operation, you don't want to make it one person, because heaven forbid that one person is the harasser. You've set it up to fail. So you want to make sure you certainly include an HR person who's trained and educated in this area, your managers, your supervisors. Have a few people that they can make these reports to, and then make sure those people who are identified know what to do when they get that report, and they know how to respond when they get that report. For the reasons I just gave with respect to somebody who wants to put limiting criteria on how the employer should proceed in light of those allegations. And then you have to go forward and resolve the complaint and report back to the person. So just in way of quick summary, and I'm going to turn this over to Colette in short order, I would like to say that what is sexual harassment? I touched upon this. So in summary, it's the unwelcome sexual advances. It's got the double standard of an objective test and a subjective test. And then when we talk about the quid pro quo, that's something for something, and I think most of us know what that is. What creates the hostile work environment? Again, just by way of recap here, I think the message here is when we're talking about preventing the hostile work environment, that to help set the tone for the culture, that if a manager or supervisor is standing with a group of employees, somebody tells a joke that is offensive, that it's not laughed at. It's the person is told that that's not funny, and that the reprimand, they're told about it. Because if you participate in that type of humor, if you turn a blind eye to it, this goes to leadership. This goes to the word I've used probably 50,000 times so far, culture, and it goes to tolerance. And you just can't tolerate that type of conduct in the workplace. So what might seem to be trivial, what might seem to be insignificant. Oh, it was a poor joke. The person shouldn't have told it. It's like, you know what? Somebody might be testing boundaries here. You don't know. You need to stop it before it starts. Okay? Employer's liability for supervisory harassment. So if I didn't get your attention with all those damages slides about what this costs, supervisors have personal liability. That should help get the supervisor's attention for the stakes that we have here. How to avoid it, we touched upon these points, and that is have to have good policies in place. You want to encourage employees to trigger your policy, and then you want to act upon those policies promptly and responsibly. These are essentially what we're talking about here are good management principles. Okay, you want to make sure there are not unwelcome date requests, flirting. I gave this talk about a year ago, and a woman in the audience said to me, "Boy, it seems like you're taking romance out of the workplace." I said, "You know, we're not. I'm not saying take romance out of the workplace. What we're talking about here is, first of all, romance probably should be outside the workplace. That has no place in the workplace. But what we're talking about here are things that people should know. These are common sense things that supervisors and managers need to be hyper vigilant in safeguarding, boundary violations, not tolerating jokes, gestures, comments, banter, using sexist or demeaning terms. All those things need to be avoided. They've got no place in the workplace. And I'd just like to wrap up on one cautionary note about retaliation. Because we see retaliation, it can come in any discrimination case. It can come in a race case, a culture case. It can come in a sexual harassment case. If somebody comes forward and a woman makes a complaint about being sexually harassed, and let's say that those allegations were unfounded, and the employer says, you know, this person's really been a problem all along. Now she's making these types of allegations. I'm going to fire her. That's retaliation. Retaliation falls into this category of knee-jerk responses, and that's where somebody makes an adverse employment decision because they didn't like what the person did or said. But when an employee is engaging in protected activity, the employer cannot react with an adverse employment decision because that violates Title VII. And retaliation occurs, for example, in the sexual harassment hypothetical I just gave you. The employer needs to be patient. If you're patient, we will win that case. We will show that the allegations were unfounded. We'll be able to put the evidence forward, and you'll win. But what happens is when you take the adverse employment action against that person, and you give them a retaliation claim. So what happens? The court can decide that there is no violation of Title VII for the initial allegations, but the retaliation claim is valid, and then they can get all those damages we talked about earlier because of the retaliation claim. And the statistics, the charges are astronomical. 1/3 of all charges filed with the EEOC contain a retaliation claim. Sometimes it might be employees who are just gaming the system, that they're going to engage in protected activity, knowing that if you take an adverse employment action against them because they engaged in protected activity, that they will now have a retaliation claim. So sometimes an employee can smell that they might be getting ready to be terminated, that they're going through certain problems at work, that they're being progressively disciplined, everything's being handled the right way, and then they engage in a protected activity like reporting harassment, taking leave that might be protected under the FMLA or something like that. You have to analyze the situation based on the allegations that are being made by the employee. You cannot take actions because of the allegations that are being made by the employee. So the bottom line here is take the high road. Always take the high road with the employee. Don't let anybody get your goat. So avoid the knee-jerk reaction, and don't give somebody a retaliation claim where they've got no case to begin with. So that's my part of the presentation today. Thank you for your patience. Thank you for attending. And now let's see how well I did by seeing what the results are going to be on the quiz. So I'd like to introduce you to my partner, Colette Copon. If you thought there was a family resemblance in the earlier photograph, you're right, there is a family resemblance in the earlier photograph. But Colette's in charge of our employment law team. So Colette, thank you for being with us today.
All right, thank you, Andy, and thank you all for joining us on today's call. So before we launch into some discussion about state law considerations and how to conduct investigations into sexual harassment claims in your workplaces, we'll just recap briefly on what Andy's been speaking about with respect to sexual harassment at the federal level. So we'll walk through a couple true and false questions here, and then we'll take a quick look at a hypothetical. So the first question here is true or false. The promise of reward or threat of punishment in exchange for sexual favors must be explicit in order to constitute quid pro quo sexual harassment. And this isn't a polling question, we can just talk through this, but the answer to this is false. The promise of reward or threat of punishment in exchange for sexual favors does not need to be explicit to constitute quid pro quo sexual harassment. So if a supervisor doesn't say explicitly, you need to give me this in order to get that promotion, the supervisor, we can have winking, euphemisms, body language, all sorts of implied conduct or implication that that's what's expected, and that will still qualify as quid pro quo sexual harassment. Number two, an employee who gives in to the demand for sex in order to avoid negative consequences forfeits his or her claim for quid pro quo sexual harassment. So this is also false. Just because an employee submits and may submit to the request for sexual favor or whatever that act is, does not mean that that is not still sexual harassment. And our last one here, if the alleged harasser denies the charge, a claim for sexual harassment cannot be successful without a neutral witness or documentary evidence supporting the complainant's accusations. This is also false, and we'll talk about this more as we get into the investigation portion of our discussion today. But oftentimes, maybe not oftentimes, but you will see not infrequently that it's just a he said, she said. And so just because you only have two witnesses to rely on doesn't mean that you can't make a determination. So just because the alleged harasser denies it doesn't mean that you're going to find that the alleged harasser is lying, that he had a reason to deny it and the victim was credible. And we'll talk more about how to make those determinations as we get into the investigation portion here in a little bit. So this is a slightly more lengthy hypothetical that will be worth a little consideration here. So Tamika starts as a supervisor for the commission in Yuba County. The other 4 supervisors and all the field crews at the Yuba County office are men. Eve, the district administrator, does not think that women should be field supervisors and resents that headquarters is forcing an affirmative action case on her office. Eve tells the other supervisors and crew members the field is no place for a woman. She tells Tamika's crew to keep an eye on her and use your own judgment in the field. During office meetings, around the office, and in emails, Eve consistently refers to Tamika as Little One, Wonder Girl, Oprah Jr., and similar nicknames. Tamika tells Eve she is undermining her, but Eve tells her to grow a pair or you'll never make it out here. So here are our options. So choose the best answer. So we'll take a minute to read through these answers, and then on the next screen you'll have a chance to select which one you think is the best choice here. So what is the best answer? Eve's use of diminutive nicknames and undermining of Tamika's authority is okay because Tamika needs to demonstrate the ability to supervise men in what can be an inherently crude environment. B, Eve's nicknames and statements undermining Tamika's authority have created a hostile work environment. Or C, because Eve has no interest in Tamika sexually, her hostile behavior is not actionable as sexual harassment. So please take a second to think through which letter you think fits here. And then please go ahead and vote. All right, so 100% chose B, and that is absolutely correct. Eve's nicknames and statements undermining Tamika's authority have created a hostile work environment. It does not matter that they are of the same sex. It does not matter that it is a predominantly male field. The fact that she's using those nicknames derogatorily and constantly picking on Eve is creating a hostile work environment that should not exist. So turning now to a few state law considerations, we've been talking largely to this point about federal law, global best practices and considerations that apply across the board. But I'd like to spend just a few minutes highlighting some state law considerations, because in addition to the EEOC, which Andy was talking about earlier, each state has its own division that's charged with protecting the civil rights of the state's residents, which includes employment discrimination. And states also have their own laws, which sometimes are even more severe and restrictive than the Title VII and the federal laws that we see on the books. So we're going to take a quick look at California and New York as examples, and we'll talk through some of the implications of these state law statutes. So California statute says that California's Fair Employment and Housing Act defines sexual harassment as unwanted sexual advances or visual, verbal, or physical conduct of a sexual nature. So this is a very similar definition to the one that Andy put up earlier. So unwanted sexual advances, this includes not just red light, Harvey Weinstein type behavior, but this includes things like asking someone out on a date or leaving little love notes for someone. It includes that what might be perceived as more minor behavior, but is still an unwanted sexual advance. And we see here in the second paragraph that this includes many forms of offensive behavior, including harassment based on gender, gender identity, gender expression, transgender status, harassment based on pregnancy, childbirth, breastfeeding, and related medical conditions. A lot of these state law definitions look very similar and include very similar categories as to what's protected, but it's worth taking a look at your state statute just to make sure that you've got all your bases covered. So also in California, they have unique posting requirements, so posting the Fair Employment and Housing Act signage regarding sexual harassment, distributing information to employees about sexual harassment, and also providing sexual harassment training to supervisors and employees. And for those of you that are in California, you know that this second portion here, the and employees, is a new addition to the California law. Historically, it was just supervisors that required training, but now the state has also formalized the fact that employees need training as well. And California is one among many states that are including this training requirement. So California, Connecticut, Maine, New York, Delaware, they all have passed statutes requiring training on sexual harassment, and lots of other states encourage training through statute and case law. And the goal really of all of these statutes and of our presentation today is really to reinforce the importance of creating workplace culture that promotes safety, that promotes an environment where everyone feels comfortable coming to work, and where they can be the most effective employee that they can be. So this slide kind of highlights how California, as one example, is more severe than the federal laws on the books with respect to employment law. So this first bullet point here, under federal law, negligence theory only. So under federal law, an employer is not automatically liable. So all those best practices that Andy was talking about, being proactive about creating this culture in your workplace, of having your sexual harassment policy, of doing your investigation right away when a complaint comes in. Having all of those best practices in place, creating that environment, that's a defense to a federal action. But under California law, an employer is automatically liable for harassment by managers and supervisors. There's no defense to it. It's a strict liability situation. Under the second bullet point, we can see federal law, an employer is not liable if for the things we just discussed. If they have exercised reasonable care, the employee unreasonably failed to take advantage of opportunities to avoid harm. And again, under California law, there's no defense if there's harassment. Federal law, Andy had mentioned this earlier, the Title VII applies only with 15 employees or more, but California is one of those states, like many other states, where all employers, even those employing one person or sole proprietors, are subject to their anti-discrimination laws. And then this last bullet here, I don't think we mentioned this, but federal law, Title VII, it does not apply to independent contractors, volunteers, and unpaid interns, but many state laws do, and California is one of those state laws as well. So we can see here California is a good example of how states are sometimes more restrictive than the federal law. So a couple of quick questions here to recap. So true or false? Unpaid interns and volunteers are protected under federal laws against sexual harassment. Okay, so this is actually false. So federal law applies to employees, but it does not extend to contractors and interns and volunteers. But certain states do apply to all those different categories of people. So California is one such state.
Trick question.
Trick question. All right. Second question here. California law is broader than federal law in providing protection against sexual harassment. And that is true. California law, like many states, provides more stringent requirements on employers with respect to sexual harassment than the federal statute does. All right. So now turning briefly to New York. So almost a year ago, back in April of 2018, New York made several major amendments to the New York Human Rights Law, which is their anti-discrimination and sexual harassment law. And one of the most significant aspects of the bill was the mandate that New York employers adopt robust sexual harassment policies, as well as provide mandatory anti-sexual harassment training to all employees, not just managers. So just like California, New York has decided that the training needs to be given to not just supervisors, not just managers, but to all employees. And this law governs employers with 4 or more employees that need to follow these policies. The New York website that was put together by the New York Commissioner of Labor and the New York State Human Rights Division is listed under that first bullet point. It's a great resource and has model policies, complaint forms, and training. And so it's a really good resource for employers in New York and really in other states as well, looking for some guidance in this area. All right, so turning now to conducting an investigation. So what happens? Someone comes in and they say, such and such has approached me and said this to me and now I feel uncomfortable, or you hear that so-and-so asked someone else out and now that person's really uncomfortable, or you have some sort of sexual harassment complaint come in. The most important thing to remember here is that the time starts running as soon as that complaint comes in. As soon as you have noticed that there is an allegation of sexual harassment, the employer needs to take action right away. And as Andy was mentioning earlier, employers have an affirmative duty to promptly and thoroughly investigate any claim of harassment, discrimination, or retaliation through a formal workplace investigation. So what does an investigation look like? We're going to walk through each one of these 6 bullet points over the next 15 or 20 minutes and talk about what this process looks like. But this is what the overview of what we'll be discussing is. Preliminary considerations, selecting who your investigator will be, collecting evidence, making a final determination, taking corrective action, and then communicating results to the appropriate parties. So turning first to preliminary considerations. An employer should make it clear, sorry, I lost my place here for a second. So our first preliminary consideration is confidentiality. So as Andy mentioned, an employer should make it clear to employees that they will protect the confidentiality of the harassment allegations to the extent possible. Once you have notice of an allegation, you have to investigate. And that means that you have to talk to and interview the accused harasser. You may have to interview other witnesses. And depending on the circumstances, you might not have to say the name. Maybe you can just describe the incident and the person won't, the accused harasser won't know who it is, but likely they're going to figure it out. They're going to know what the allegation is. And so you cannot promise complete confidentiality because you won't be able to conduct an effective investigation without revealing certain information. So making sure that you address that with your complainant early on and making sure that they're aware of the fact that you will try to protect their confidentiality, but only to the extent possible, that you're setting expectations appropriately from the beginning. Second preliminary consideration is whether there are any immediate steps that need to be taken. Are there any intermediate measures that you need to take? So for example, if the complaining person, the alleged victim, is working at the same time as the alleged harasser, you might want to schedule changes so that there's not contact between the parties. You might transfer the alleged harasser to a different department. Or if the circumstances are extreme enough, you might consider placing the alleged harasser on non-disciplinary leave with pay pending the conclusion of the investigation. One thing to be mindful of when you're thinking about whether to put someone on a leave of absence or move someone to a different department or change someone's schedule is that the complainant, so the alleged victim, should not be involuntarily transferred or otherwise burdened. So the person that has made the complaint of harassment should not be the one to be moved unless that's something that they're asking for. And the reason for that is the retaliation idea that Andy was talking about earlier. You don't want the complaining person, the victim, to feel like they're being retaliated against because they have come forward. You want to create an environment and a culture where that person feels safe coming forward. They don't feel like they're going to be penalized or taken advantage of in any way because they've made this complaint. And so to the extent that there's going to be a transfer or change in schedules, that should really be on the accused harasser while you're making the investigation and come to a determination. So it's not a punitive measure against the harasser, it's just a temporary intermediate step while you conduct your investigation. And retaliation, like I just mentioned, we want to make sure that we're being mindful of that as we consider the early implications of our investigation. So choosing an investigator. So one consideration right away will be who should conduct this investigation? Who should be talking to these witnesses, to the alleged harasser? Should I bring a lawyer in here? Do I need to bring in some third party? And the answer is no. Typically, you will be handling these in-house. You will have your HR person that's handling the investigation. You'll have a supervisor that's handling the investigation. But it should be somebody that is unbiased, someone that understands the purpose of the investigation, someone that's knowledgeable about your workplace, about your company's policies, and someone that's credible and objective. So you want to make sure that whoever it is someone that is able to maintain a degree of confidentiality, someone that acts discreetly and isn't going to be sharing things unnecessarily, someone in your workplace that people trust, someone that's above reproach, so that everyone involved in the investigative process has a comfort level and trust in the system that they're going to get a fair shake. And that includes both the accused harasser as well as the alleged victim. We want to make sure that everyone feels that they're being treated even-handedly, and that will avoid a lot of problems down the road, regardless of what the result of the investigation are. One other thing to be aware of in choosing your investigator is that you want to make sure that the individual that is conducting the investigation doesn't have a potential conflict. So for example, the alleged harasser shouldn't be having supervisory authority over the individual conducting the investigation. There shouldn't be any direct or indirect control over the investigation by the accused harasser. So we want to make sure that all those chains of command are straightened out and that this investigator is truly an independent person that's not in any way going to be affected by what the outcome of their investigation is. All right, so now once we have our investigator, now we start talking about interviews. Who do we need to talk to? Who's going to be part of that process? What do these interviews look like? So these three categories of people are definitely going to be your people that you're going to be wanting to talk to. So first, your complaining employee. That may be the first person that you speak with. The complaining employee might be the first person that walks in and says, I have a complaint. You may have heard about this through a third party. Maybe an employee witnessed sexual harassment, in which case you haven't spoken with the victim yet. So you'll want to make sure that you speak with the alleged victim. You'll make sure that you speak with the complaining party, whether it's the victim or whether it's an innocent observer that just happened to witness this event. You'll want to talk to any other witnesses. Maybe someone else witnessed it. Maybe you learned through your first interview that this has been ongoing and there are other people that are involved. And then usually last, you'll want to speak with the alleged harasser, and you'll want to have all your facts and information ready before you go into that final interview with the alleged harasser. In terms of questions that you want to ask once you're in these interviews, you'll want to find out the details of the incident. So who said what to whom, what exactly happened, when did the incident occur, is it still ongoing, where did it occur, how often did it occur, how did it affect you. So finding out all the details you can about this particular incident. And then also finding out about the details immediately following the incident. How did you react? What response did you have when the incident occurred? If you're talking to the victim, you want to find out, what did you say to the harasser when that happened to you? Did you talk to anybody else? How did you feel after that? How did this affect you subsequently? And see the details about what happened after the incident. And then any other evidence that might be out there. You want to find out if anyone else has relevant information. Are there other witnesses? You also want to find out if there's any notes, if there's any physical evidence or other documentation. Maybe the harasser has been sending text messages. Maybe he's been leaving little notes. Maybe there's other sorts of documentation, emails. And so making sure that you ask about all of those things in your interview of the complaining employee, of the victim, will be important for your investigation. With the harasser, the alleged harasser, you'll want to ask similar sorts of questions, and you'll want to give the harasser an opportunity to say their version of the events. You want to find out, what is your response to these allegations? This is what was said about you. What is your response? And if the harasser claims that the allegations are false, if the harasser denies the allegations, then you can ask why. Why would the complainant lie about this? Why would the complainant make all of this up? Maybe there's some underlying dispute here where the complaining party is lying because it turned out that they had a big fight, or maybe there's some family relationship and there's been a dispute, and so now the alleged victim is just making this complaint up. So we want to make sure that we give the alleged harasser an opportunity to speak their piece, provide their side of the story, and any insight they have into what their version of the events are. And you also want to make sure from the harasser that you similarly find out if there's any other witnesses, any other people that have relevant information, any other notes, physical evidence, or other documentation regarding the incident. So this is my summary slide here on this, the who, what, when, where, how. When you forget what sort of questions to ask in interviews, I think it's always good to go back to the basics. Who said what to whom, what happened, when did it happen, where did it happen, how did it happen? And these sort of basic question words can help you generate the questions that you need to ask in these interviews. And then once you've completed your interviews, then you have to look, is there any other evidence? If there's conflicting versions of events, if it's a he said, she said situation, Do we have any corroboration? Are there any other witnesses out there that can say, yeah, I saw so-and-so give that victim a funny look, or yes, I saw that exchange of notes in the hallway? Is there any documentation that corroborates one version of events over another version of events? And then credibility determinations. Credibility determinations are something that we make every day. It's a gut instinct. I trust this person, I don't trust this person. I believe this story, but I don't believe that story. And oftentimes, one of the most critical jobs of an investigator is to make credibility determinations. You may very well just be interviewing the alleged harasser and the victim. And those might be the only two stories that you get. And so when you're in that circumstance, then the interviewer has to make a credibility determination. And so there are a couple of things, and the EEOC provides guidance on this as to what can be used in looking at credibility determinations. And they provide 5 factors to look at, which I think are helpful in driving the considerations here. The first is inherent plausibility. So is the testimony believable on its face? Does it make sense? Is what this complaining victim saying to me make sense, or does it sound completely out of reality? Demeanor. Did the person seem to be telling the truth or lying? Was the accused harasser averting eye contact? Was he really sweaty? Did he seem really nervous? Maybe that was because he was just uncomfortable having the conversation with you. Maybe it was because he had something to hide. But considering demeanor as well. The third consideration is whether there's a motive to falsify. Did the person have a reason to lie? In your interviews, did it come out that somebody had some motivation to tell a lie about someone else, make a false accusation? And the fourth is corroboration. So like we discussed, whether there's witness testimony or physical evidence to corroborate one side versus the other. And the fifth consideration is past record. So past record is always a little bit tricky because perhaps your accused has had 3 or 4 incidents in the past where they've been caught lying about something. That doesn't mean that they are telling the truth here and they didn't do this bad act. But it's something that you're allowed to consider when you're making your credibility determination. You're allowed to look at whether this has been a pristine employee for the last 15 years, and now you have one new person coming in who might have a bone to pick for some reason, making an accusation. And those are all considerations that you're allowed to consider in making your credibility determination. And so after that, after you've gathered all of your evidence, after you've evaluated the credibility of your witnesses, you have to make a final determination. So there has to be a result to your investigation. What's the result? Is the person do it? Do we believe that the person did it? Do we believe that the person didn't do it? What is the result of our investigation? And so in making that determination, it might be the investigator that's making this determination, or it might be management that's making this determination. But whoever it is needs to have all of the investigative materials, all of the investigative information in front of them to make this evaluation. And the final determination is based on these things. It's based on the credibility of the parties and the witnesses. It's based on the strength of the evidence. It's based on the factual conclusions and the unresolved factual issues. If you think that there's too much out there that can't be resolved, maybe that tends to favor not finding that it's a substantiated allegation. And whether the violation of harassment policy occurred. So that is the bottom line. It's figuring out whether there's been a violation of your policy here and then deciding what to do about it. So like I mentioned, the investigator or management will be responsible for making the final determination here. And then management really needs to make this decision as to how to correct this action. So if indeed you find that there has been sexual harassment, that there's been a violation of company policy, then immediate and appropriate corrective action needs to be taken. So there's 2 parts to this action. The first is the putative piece. Stop the harassment and ensure it does not recur. And so this is the action that we're going to be taking against the harasser. And then the second piece is a remediation piece. And that's correcting any effect that this may have had on the employee who was victimized by the harassment. So we'll take these in turn. So stop the harassment and ensure it does not recur. We often counsel employers to have a progressive discipline approach. And so it may be that you have red light behavior that's really egregious. It's a first-time incident, but it's so out of bounds with what your mission is and with what your expectations are of your employees that it warrants an extreme disciplinary response like termination. Or it may be that this is a first-time offense and maybe it was a verbal statement or a couple of verbal comments that were made and the harasser omitted it right away, apologized profusely, promised it would never do it again, and you believe that person. There are different forms of discipline that you can take depending on the circumstances. And so you can impose just a warning and a reprimand, letting the person know we take this seriously, we have found that there is a violation of our policy here, that you have committed sexual harassment in violation of our policy, we don't have room for that here, and you need to knock it off and get back to work. Or you can have transfer or reassignment if you think that that's going to help stop the problem and give comfort that the harasser and the victim are no longer together in the same area. A demotion, reduction of wages, a suspension, discharge, training, counseling, monitoring. There's a whole realm of disciplinary actions that are available to you as the employer in these situations. And I think it's important to look at every case and the facts of every case specifically when you're coming up with what the appropriate discipline is in these sorts of situations. No two cases are alike. No two employers are alike in terms of how they want to handle these, but we want to make sure that we're applying even-handed approaches. And so if you have a situation where someone acts in a certain way and they get a verbal reprimand and then a year later someone does something very similar but you really like that person, you don't want to terminate them, you have to make sure that you're applying this in a fair and balanced manner, however you decide to do that. And then the remediation effect here, correcting the effect on the employee. So it's possible that the victim, while the harassment was going on, took some time off of work because she didn't or he didn't want to come into the office, felt nervous, felt anxious, and so took a couple of days off. Restoring leave that was taken because of the harassment. If there was a negative evaluation that arose from the harassment, if it's a supervisee situation, then maybe there was a negative evaluation that resulted because the supervisee wouldn't perform the quid pro quo, then making sure that that's taken out accordingly from the file. Monitoring treatment of the employee to ensure that he or she is not subject to retaliation. This is an important one, keeping an eye on that employee that made the complaint, making sure that he or she is being protected, isn't being treated in any adverse way around the time of this action. And then correction of any other harm caused by the harassment. Okay. So once you have remediated and let the victim know that we've handled this and this is how we're going to be moving forward in terms of discipline and remediation, we also want to make sure that we communicate our findings. So management should inform both parties about these measures. So the harasser should be told this is what we found and this is the action that we're taking because of what we found. And the victim should also be told this is what we found, this is the action that we're taking because of what we found. So that both parties know that the process was applied even-handedly and fairly and everyone knows what's happening next. There's no surprises. You've been managing expectations from the beginning. From the minute that the victim came in complaining, you let the victim know we're looking into this right away, we take this seriously, we will get back to you with the results, to working through your investigation with your interviews, collecting your documents, getting your conclusion, coming up with a plan with respect to remediation and discipline, and then communicating that appropriately to the two parties. And then I have down here document, document, document. It's important to make sure that as you are going through these steps that you're making notes to your file, that you have a record of the process that you're following, so that if push comes to shove down the road, that you are secure in your findings and in your process to support the path that you've taken here. So this is just a recap of the things we've talked about with respect to conducting an investigation: preliminary considerations, choosing your investigator, collecting your evidence, making that final determination, taking corrective action, and communicating your results to the appropriate parties. Okay, so now another quick little quiz here. True or false? So true or false, an employer does not need to investigate sexual harassment until an employee makes a complaint. Great. False. Yes, absolutely. So once you have notice of a complaint of harassment, you have to investigate. Doesn't matter if it comes in from the victim, him or herself, or whether it comes in from a third-party bystander. That is absolutely right. Number 2, an employer can ask an employee who reports harassment to remain home on a paid administrative leave pending the results of an investigation. False, yes. So this is false, but this is a tricky question. So the question here is true or false, an employer can ask an employee who reports harassment to remain home on paid administrative leave. And the trick here is that the person that reports the harassment is the person we don't want to retaliate against. So if someone's going to be on paid leave, that should be the accused harasser. Unless for some reason the person making the report has requested that, or there's some reason for doing that, we want to be very, very careful before taking any action against that person making the report of harassment. Number 3, true or false, the accused in a sexual harassment investigation has the right to have an attorney present during his or her interview. And this is a trick because we didn't talk about it, but let's see what the results are. Okay, so this is actually false. An accused in a sexual harassment investigation does not have the right to have an attorney present during his or her interview. That is entirely internal employer policy. So if you do not want to have that lawyer present, and I think it would be in your interest not to have that lawyer present for purposes of that interview, then you do not have to let that lawyer in, and you can tell the employee that you can either comply with our investigation and conduct this investigation with us by submitting to this interview, or you will be discharged. I mean, they have to, as a condition of their employment, partake in your process. And so part of what we want to make sure that we're doing with our harassment policies is creating an environment to reinforce that these policies are being applied even-handedly. And I'm going to skip through this next hypothetical just so we have a couple minutes here for abusive conduct in the workplace. Abusive conduct in the workplace is a really interesting area of law that is changing all the time. And we're seeing more and more states, like Andy discussed with the EEOC, a lot of states are starting to talk more about what we call healthy workplace bills and laws. So as we've talked about at length today, federal and state laws already prohibit harassment, hostile work environment based on protected classes, so your age, sex, race, disability, national origin, all that sort of stuff. But there are some states that have begun taking legislative steps to address concerns about abusive conduct in the workplace that extend beyond these protected classes. So for example, the bullying that's based on something unrelated to protected class, bullying based on how someone dresses, or based on someone liking Star Trek, or not knowing what March Madness is. All these things that make people feel excluded or not welcome in the workplace. And so states have been starting to look at, well, how can we help employers foster and create an environment where everyone is able to be productive and feel like they're in a professional work environment. So why healthy workplace laws? For the obvious reasons. strengthens the workplace. It benefits the employer since abusive work environments lead to low morale, reduced productivity, increased turnover, increase in medical and workers' compensation claims. And the key here is to prevent workplace bullying before it starts. Even if your state does not have a statute like this, even if your state doesn't require it, I think it's still a best practice to create a culture where everyone feels like they're able to report an abusive situation when it happens. And that's regardless of whether it's based on their race or their sex, or whether it's based on how they dress or the glasses they wear or whatever it is. You want to have an environment where people feel like they can have their concerns addressed in real time. So state initiatives, these are just a couple of examples. Tennessee was the first state to enact healthy workplace legislation in 2014. But Tennessee, like these other two I've listed up here, North Dakota and Utah, were also early jumper-ons to this sort of initiative. All three of these states, like most of the other states that have enacted this sort of legislation, applies only to public sector employees. So it does not apply or implicate private employers at all. Now, California is an exception to that. California requires that all employers with 50 or more employees provide training on the prevention of abusive conduct. And abusive conduct under their statute is conduct of an employer or employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. So it's just like the conduct we've been talking about all day here, but it's being driven not by a person's sex or race or whatever it is, but based on whatever. It's just this bullying sort of behavior. Skip through here. Now in California, even though training is required, there is no private right of action for workplace bullying in California. So to the extent that the harassment is not based on a protected class, there's not a private right of action. But, and that's a big but, there are possible other claims here. So if there's some sort of physical component to it, there still might be a claim for something like assault or battery or intentional infliction of emotional distress. And that goes across all states, not just California. There's always a risk that some other sort of claim might be filed, even if it's not one of these civil rights discrimination sorts of claims. And so that's why it's really important to have a culture in place where you're tamping down and eliminating this sort of bad conduct. So best practices, employers should have a policy on abusive conduct. Supervisors should report abusive conduct as they would harassment, and employers should investigate complaints of abusive conduct just as they would harassment. So likely, if you look at your mission statement, code of conduct, core values, you're likely already incorporating elements of this. I think most everyone on this phone is doing the good work that will necessitate and precipitate good environment and wanting to have everyone being treated equally and fairly and in a healthy workplace. So much of what you need is probably already available to you, and I think just formalizing that into an anti-abusive conduct can help bring everyone onto the same page. So I think with that, we'll leave a few minutes for questions here. I think we have about 5 or 6 minutes here. So thank you all very much for joining us today. And thank you so much to Christian Brothers for having us. We really appreciate being here.
Thank you. We'll now open up the floor for questions. As a reminder, to ask a question, please type the question into the question box, which can be found to the left of the presentation window, and then just click Submit. Our first question, Colette and Andy, what do you do if the observer or the one being bullied doesn't want to take action against the accused?
Well, I would be guided by the same principles that we have in the area of sexual harassment law, and that is look at it in terms of affirmative duties and taking action to talk to the person who's engaging that behavior and telling them to stop doing it. So you want to find out, depending on the egregiousness of the behavior, how deep the investigation has to be, whether you're going to go into a big protocol that Colette identified before about having a trained investigator look into it, depending on the nature of the bullying, if it's verbal versus physical. But for the most part, I think I go back to the opening comments about respect in the workplace and the culture in the workplace, and that it needs to be the leadership in the organization who sets that tone. And by telling the employee that you really appreciate them coming forward and saying this to you, that you will keep it in confidence, but that you need to act on it, because that type of behavior cannot be tolerated in this organization. That accomplishes the goal of what everybody is trying to accomplish today in the legislature, in the court system, in the EEOC, in the state legislatures. So you can't bury your head in the sand anymore. Those days are over, and it needs to be addressed.
Our next question: at what point do you need a written report for the person making the complaint?
You never need a written report. Well, let me make sure I understand the question. We're talking about a report of the findings of the investigation versus a report of the complaint.
The report of the complaint.
Okay. The complaint itself does not have to be in writing because of the affirmative duty. The complaint can come from any source, verbal, be hearsay, but it has to be acted upon. And then, depending on the nature of the complaint, you go through your process, and it may or may not require a written report, depending on the nature of the allegations that are being made, the severity of the allegations being made. But I think the takeaway that I'd like to have people leave this webinar with is that when a complaint is made, even if it's an anonymous phone call tip, it has to be acted upon. It doesn't have to be in writing. It doesn't have to be signed, because that's what allows you to see if there's a problem in that workplace. And that's what you need to move on. That's what you need to act on. And I know it might be, if it comes, some employers will set up a 1-800 number. I don't necessarily advocate that. But some employers will set up a 1-800 number. People can make anonymous phone call tips in the evening, after hours, so that the employer is trying to head off any problems in the workplace.
And I would just add to that, just because the complaint comes in not in writing, because it comes in verbally, your investigator will still have a note of that in the file. You'll want to make sure that you've recorded that for yourself internally for your investigation, but it's not necessary to force the complainant to put that in writing and sign off on it.
Good point.
Thank you. When placing an alleged abuser or harasser on leave, does it need to be paid? And a second follow-up to that, if the conclusion of the investigation finds them guilty and part of the discipline is to remove them from employment, do they have to be paid out for their employment time?
That's a good question. I think on the paid leave part, a lot of this is going to depend upon the circumstances, how quickly you're able to act on it. I think the safest course is going to be if you're making a decision that the person should not be in the workplace because of the nature of the allegations being made, that they're a threat to somebody else in the workplace, then you want to conduct your investigation quickly. You probably want to get a few things lined up. You probably want to talk to this person before you put them on leave. And at that point, you're moving towards a finding that this person committed or engaged in this type of conduct. You may be okay in doing it without pay. The safest way would be to do it with pay until you can complete your investigation. But time is going to be of the essence here. And there's going to be a lot of strategic decisions that enter into what takes place. And, and this comes up, particularly when we're dealing with high schools, and where it might might not be just a danger to a coworker. It could be a danger to the population. And I think when we move into those types of areas where we're less dealing with an employment type case and dealing more with conduct against the constituency that you're serving, frequently you'll see the person being placed on leave without pay. But when you're dealing more in the employment context with how employees are relating to each other, until you get to the bottom of it, the safer course of action would be what Colette advised, with going with leave with pay, until you make a determination that you're comfortable with on whether or not the person is going to be terminated, progressively disciplined, or what's going to take place. Because if you conclude the investigation and decide that you cannot make a decision on the allegations, and the person will be allowed to continue to work there, and they've been reprimanded, in essence, that could create other types of problems. So the safer course of action would be to do it with pay.
Perfect. Thank you. That's all the time we have questions. That's all the time we have for questions today. If you have more specific questions or some of the questions that were asked that weren't answered, you can contact Andy or Colette using the information on the screen provided in front of you. And for additional information about Christian Brothers Services and the risk pooling services provided by Christian Brothers Services, you can contact Elton Sherrill at elton.sherrill@cbservices.org. If you need a certificate of completion for attending today's webinar, please contact Laura Hart at Christian Brothers Services, providing the information on the screen using the contact information provided at the bottom of the screen. And she will provide you with an emailed certificate of requirement. As a reminder, a downloadable copy of today's presentation can be found by clicking on the light green icon with a piece of paper on it at the bottom of the screen. This was the 6th of 10 webinars in our 2019 webinar series, spring webinar series. Please join us for our next webinar on Thursday, April 25th, when we'll be discussing Plan on Plan Giving, when we will discuss how to maximize your plan giving potential even with limited staff and limited resources. To view or register for all the webinars in the spring series, please visit us at cbservices.org/webinars.php. You can also visit the site to view any past webinars on demand. Once again, thank you to our speakers, Mr. Andy Copon and Ms. Colette Copon, as well as all of you for attending today's webinar.